So in order of presentation, our panelists are as follows. Jonathan Collins, an assistant professor of education and political science by courtesy. His research focuses on urban school reform, local politics, race and ethnicity, civic engagement, and deliberative democracy. His research has been published in the APSR and elsewhere in a number of other venues. Our second speaker will be Professor Nicole Gonzalez Van Cleve, who's an associate professor of sociology and an affiliated scholar with the American Bar Foundation in Chicago, Illinois. She's the author of the acclaimed book, Crook County, Racism and Injustice in America's Largest Criminal Court, which is the winner of 11 awards or final distinctions for its contributions. And third is Professor Bonnie Honig, who's the Nancy Duke Lewis Professor of Modern Culture and Media and Political Science, and by courtesy in Religious Studies and Theater and Performance Studies. She's the author of several books, most recently A Feminist Theory of Refusal and Shell Shocked, Feminist Criticism After Trump. She will be followed by Professor Emily Owen, who's the David and Michelle Ebersman Assistant Professor of History at Brown and works on histories of race, gender, and sexuality. Her forthcoming book, The Fantasy of Consent, Violence and Survival in Antebellum New Orleans, surfaces the survival strategies of women of color whose lives were bound by sexual labor under slavery. Next, we will hear from Brandon D.L. Marshall, who's an associate professor of epidemiology at the Brown University School of Public Health and the founding director of the People, Place, and Health Collective at Brown. His research focuses on substance use epidemiology with a specific emphasis on harm reduction research and overdose prevention. Finally, we will hear from Donnell Williamson, who is a PhD student in religious and critical thought at Brown University. His scholarship focuses on modern religious thought and historical philosophy. His primary research interests include philosophy of religion, religion and politics, African-American religious traditions, with an emphasis on the intellectual histories of Kierkegaard and Frederick Douglass. I'm not sure this is the exact order that we agreed on, so people might appear in a separate order, but hang with us. We will definitely hear from everyone today. So thank you very much for listening to my brief introduction. We will now begin our conversation with Jonathan Collins. Jonathan?
Thank you, Professor Rose, for the introduction, and thank you to CSREA for organizing this event and allowing me to be a part of it. It really is an honor, and to be especially a part of such an esteemed panel. I want to talk about sort of Derek Chauvin and George Floyd situation from the perspective of education policy and race. And so I guess I'll start by talking about Yates High School. And so Yates High School is a school in Houston, Texas, and it's a school that really, it lazily tells us this American story. And so through court order, Houston desegregated schools in the 70s. They mainly used magnet programs, and it worked for a few of the schools there. Yates High School went into the opposite direction though. By the 90s, it was just as segregated as it had been during the Jim Crow era. The district itself, Houston Independent School District, they blamed the culture of the school. They hired a new principal, fired teachers, and they did this all in an effort to sort of quote unquote clean up the culture. Yet still by 2007, a Johns Hopkins report deemed Yates High School to be a quote unquote dropout factory. Now, like many Black spaces though, that school produced brilliance. In fact, Yates High School is still known for its most notable alum, actress and dancer Debbie Allen, a woman who has inspired millions through her ability to control her own body. Schools like Yates also send negative messages though, especially the message that the Black body is a threat. If there's one thing that they try to do in a school full of Black children, it is to control the Black body, police the Black body, tell the Black body where it can and can't go, tell the spirit of the soul inhabiting the Black body what it can and cannot be. This is the story of many graduates of schools like Yates High School. This is the story of Yates High School alum, George Floyd. And so the question really becomes, from an education policy perspective, can integrated schools really reverse this? If we can learn together, can we do a better job of living together? More pointedly, if we can learn together, can my body no longer be seen as a threat? And simultaneously, can my mind now be truly appreciated as an asset? Now, there's evidence to back this up. There's extensive research finding pretty clear and convincing evidence that integrated schools yield better outcomes. Students perform better on standardized tests. They're less likely to drop out. They're more likely to enter and stay into the labor force. They're more likely to live a higher overall quality of life. These things are particularly robust for Black students. Dave Winter and colleagues also find evidence that desegregation efforts lead to significant decreases in violent crime. There's a growing mountain of evidence that school desegregation is good. And so that leads us to point to George Floyd and deduce that had we saved him from the ghettoized dropout factory, his life would have gone differently. But George Floyd's problem wasn't an educational outcome or any kind of proclivity to violence. His problem that he was simply a big Black man in America. And so I want to talk about Park High School in contrast to Yates High School. Park High School is this high school in Cottage Grove, Minnesota, which is about 10 or 15 minutes outside of St. Paul. It's a school that brazenly shows us a story of the American dream. It's a melting pot of kids of different cultures and backgrounds. In fact, from a purely demographic standpoint, you see a pie chart breakdown of Park High School. It almost perfectly matches the makeup of the country as a whole. It's an American school in every sense of the imagination that we imagine an American school to be. In fact, Park High School is so American that it also produced Sean Scott, who's best known for his role as Stifler in the movie American Pie. Well, now Park High is known for another notable alum, and that's Derek Chauvin. From the systemic standpoint, we'll blame Houston and the Yates High Schools. In fact, we'll uplift the Park High Schools as the central solution to racial equity and justice. Park High School's mascot is now the Wolfpack. You want to know what it was before they changed it in the 80s? The Indians. But that's the American story. The institution is charged with the responsibility of intellectual development and enlightenment. They traffic in white supremacy. And if we're lucky, when held accountable by communities of color, they make a change at the surface, but rarely at the core. So how do we know that Park High School never really changed at the core? Well, if it really had, one of the former students, ironically a dropout of that institution, would have not for a second thought that it made sense to lay his knee on a Black man's neck and choke him towards a final transition. And so we have to ask ourselves, under what conditions will the melting pot really work? Maybe we have to continue asking whether or not the melting pot can really work at all. But if we settle on questions of the former, we have to take seriously the superiority complex of white supremacy. In the famous Donnell studies, Kenneth Clark and Mamie Clark, they provide clear causal evidence that Black children as young as 3 years old develop perceptions of inferiority in relation to Blackness. What gets less attention, though, is the feeling of superiority that is generated by whiteness, an attitude that also starts at a very young age. And so to this idea of the melting pot, it becomes clear that it cannot work if one flavor is always privileged over another. And while our institutions are trying to promote optical integration, we have to really challenge our structures to create something far more substantive than that. And I think these are the important lessons to take away from an education policy standpoint, what happens in the trial and the aftermath of moving forward. Are we going to continue to blame the Yates High Schools for our problems and uplift the Park High Schools, or are we going to kind of see both high schools, both structures, both institutions as endemic of a problem that we're nowhere near close to resolving? Thank you.
That was fantastic. Thank you, Jonathan. We are now going to hear from Nicole Gonzalez Van Cleve. Nicole?
Hi, everyone. Thank you for having me. To everyone at CSREA for making this event happen. It's really an honor. I would just want to start by sharing my outrage. This verdict didn't give me peace. And the reason is that this trial was never supposed to happen. It wasn't supposed to happen because we were supposed to believe the police narrative that this was a medical incident. We were also supposed to believe the local DA who said that this wasn't a murder and there was nothing he could do to charge. In fact, he didn't see a murder there, even though the video was disturbing. I feel a sense of hope because the only reason this trial happened was because people, students, faculty, all over the nation, all over the world, took to the streets. They demanded this trial occur. And so I keep reminding anyone who will listen is that the system was working exactly how it should, in a patterned way, so that police can kill with impunity, and prosecutors and court systems and even judges continue to, in some ways, insulate police from any type of accountability, even in cases of murder. Now, when the George Floyd trial began on March 29th, since then, approximately 60 people, over 60 people, have been killed at the hands of police. And in my hometown, where my family's from, a young boy named Adam Toledo, 13 years old, surrendered with his hands up, and the police still shot him. Compliance was not enough to save this boy. And yet, similar to the case in Minnesota, similar to the narrative that the police wanted us to believe, the Chicago police created their own narrative. They said that young Adam was with a gun and was a threat to them until a video said otherwise. The prosecutors, they went along with the narrative until it was exposed by the video and people expressed outrage. What happened in this case, the Chauvin trial, is what's happening across the nation. My own research is in Chicago, and I look at how the court system continues to protect officers. They protect officers when they shade cases or plant drugs on young people. They protect officers when a suspect's dead and the police's stories don't make sense. They pressure prosecutors to never question the narrative that they put forth about why violence occurs or why excessive force occurs. And prosecutors have this perverse incentive to go along with it. If they don't go along with the police narrative, they will alienate their relationship with their star witnesses. And that is basically career suicide. For many prosecutors, they even sometimes fear police and the threat of violence. Many whistleblowers get pushed out of the office. And one of my prosecutor respondents had an ashtray thrown at his head when he tried to tell the chief prosecutor that a suspect was dead and the evidence and the story just didn't make sense. So I think what is really hard for me is that I still feel a sense of outrage. And as empirical researchers, we're not supposed to feel, we're supposed to collect data. But whose side are we on? What is our responsibility as researchers? What is our responsibility as people that conduct studies of racial violence? Isn't it our responsibility to expose and continue to speak publicly on these issues? During this pandemic, when inequality was so present in our minds, we could see the racial divide and the class divide was who was being affected by this pandemic. Lord, we knew that George Floyd had survived COVID only to be killed by police violence. That racism is not just, it is a form of violence, not metaphorically, but literally. We could see that. And to me, that feels somewhat of a turning point because for years, I've had to explain to many white Americans that racism is violence. And at this moment, it did feel transformative that people continued to understand the stakes of what's going on and how many interdependent institutions, from prosecutors to judges, to the police, to this whole code of silence that protects and rationalizes the killing of Black and Latino people, that it is rooted in racism, that it is a type of policing meant to surveil and punish extra legally Black and brown communities and those communities only. And so my hope for everyone is that this verdict, although symbolic and important and hopefully will help to heal the family, is not an end, but a beginning. It is a moment when we say we need to change the system because not one reform has been put in place since George Floyd died. Not one. And so that's why 3 people a day on average died at the hands of police over and over again until the end of this trial. This is what we need to push for. And so my hope is that white Americans who saw this as a victory don't see this as an end. They see this as a beginning, and one that will drive us forward as a community. Thank you.
Thank you very much, Nicole. Really appreciate that insight. Now we'll hear from Professor Bonnie Honig.
Great. Thank you. Can you hear me all right? Yeah. Thank you. I'm very grateful to be with you all today. I want to start by noting that on social media, the other feeling that was reported this week, in addition to outrage, was relief. Relief when the verdict in this case we're talking about was read out by the judge and then orally affirmed by each juror. Guilty, guilty, guilty. A lot of people who didn't know that they'd been holding their breath exhaled. Thank God, many said, even atheists said that. And many expressed a sense of relief. And then thoughts started to pour out. Does a case have to be this perfect for justice to be done? Broad daylight, on film, many witnesses, a man beloved. Even all of this is not normally enough, as Gwen Carr, the mother of Eric Garner, pointed out. Her son's murder was also in broad daylight, witnessed, taped, and he too was a man beloved by his friends, family, and community. But they never put together a case for Eric Garner's death, and worse yet, as Gwen Carr said, they took 5 years to not do it. Bill Barr shut the federal case down in 2019, days before the deadline for pursuing it. And then it was over. This time, though, the case went to court, but the prosecution defined the parameters of the case very narrowly. In court, the prosecution said, this is not about the police. In fact, this is a pro-police case, they said. This is about what one cop did on this one day in May 2020 in front of these witnesses. This is about one police officer who went against his training. They won the case, but it was fought on such narrow grounds. What progress can it bring? Outside, after the verdict was read in court, Minnesota Attorney General Keith Ellison took those very narrow parameters and made them as broad as can be. He wrapped the Garner case and all the other cases in which Black people have been killed at the hands of the police into the George Floyd case. The New York Times reported that he saw the Chauvin case, quote, as not merely about the death of Mr. Floyd, but also as an effort to achieve a measure of justice for all the Black families who have lost loved ones to police violence, but never saw a courtroom, unquote. That's why he invited Gwen Carr to join some of the prosecution team's meetings as they prepared the George Floyd case. Now, with the verdict rendered, Ellison was free to expand the case that he and his team had so narrowed. This case, he said, can be an inflection point. He went on, and I'm quoting, but abbreviating a bit. He said, quote, we want a new relationship between community and police. We need to re-examine the use of force. We can make enduring change, unquote. In short, he said, this one case can be not just the most narrowly threaded needle of law ever, but a big, heavy hammer that might crack the shell of policing as we know it. For that to happen, the narrowness that made this legal win possible has to be replaced with a capaciousness that brings everyone in and reimagines the meaning of security for American communities. Instead of militarizing and occupying neighborhoods, policing could be about humanizing residents and serving them as members of the public. Keith Ellison must have planned this pivot from the unbearably narrow case in court to the ambitiously broad case in the court of public opinion. This is surely why he brought Gwen Carr in. She's the hinge of the strategy, someone with her own terrible loss who also routinely reaches out to help others shoulder their burden and collectivize their pain into purpose. 2 days after George Floyd's death, she gave his family her sympathies and some advice. Unquote, quote rather, sorry. I told them I knew exactly what they were going through and for them to keep up the fight, she said. She told them, quote, don't forget, you cannot let this go, unquote. Carr is a member of Mothers of the Movement, a club no one wants to join, composed of women who have lost children, young or grown, to police violence. The night of the verdict in the Minnesota case, she appeared on the Rachel Maddow show, and she was asked by Maddow, where do you get the strength, the energy to reach out to other families, to other mothers, to endure that too, to put yourself out when their grief is so raw? And Carr answered, well, first you have to pray. And second of all, if you can just help one mother when the mother is not where you are, because sometimes they're bedridden, hospitalized, medicated, tempted to suicide, if you can talk them down and say an enlightened word, and then later they say, that really helped me, that's therapy. It makes you feel like you're doing something for the country and the other mothers, and you're doing something for yourself. Maddow had asked Carr about the toll on her. Carr reset the question by referring to the worldly power of the movement. For her, the verdict in this case was, quote, a glimmer of justice, unquote. That's not nothing, but of course, it's not enough. It's not enough for justice to glimmer when it should shine. I want to close with this. There's a pattern in the US around public things like justice and the rule of law and race. Public things in the US are prized until they're integrated. Public swimming pools, for example, were once highly valued as great community resources. When they were integrated in the 1950s, not only did white people pack off to the suburbs and put private pools into their backyards, the cities also, as Heather McGee points out in her recent book, The Sum of Us, paved over the pools that were left behind so that no one could use them. We are in the bullseye of that pattern right now. Right now, it seems like the last public things we have are the rule of law and some raggedy semblance of democracy. In the next decade or two or three, we might become a cheek-by-jowl, joyous and fractious, multicultural and multiracial democracy under the rule of law. But as the January 6th insurrectionists made clear, along with the Republican Party, white supremacists would rather abandon democracy than integrate it. They will pave it over before they will let others in. So we are at an inflection point. It is about more than this one terribly narrow case, but it is all contained in this one narrow case at the same time. The question is, what will the future of American democracy be? Thank you.
Thank you. Thank you very much, Bonnie. Now we'll hear from Brandon Marshall.
Hi, everyone. Thank you for the opportunity to join the teach-in and offer some perspectives today. And thank you to CSREA for creating this space in which we can process, express outrage, and learn from each other. So I'm an epidemiologist who studies the causes and consequences of drug use. And I also examine the effect of drug policies on the health and well-being of people who use drugs. So I want to focus my comments on the aspects of this case that were about drugs and how they relate to the long history of racist drug policies in the US and the racially determined responses to drug-related harms that we continue to see in this country. So first, I want to highlight that how and why we regulate substances and the social meaning that we assign to them is largely determined by who we perceive uses and is affected by drugs rather than the chemicals themselves. For over 100 years in the US, we've constructed what I call a racialized duality when it comes to addressing drug use in this country. The modern opioid crisis is a really good example, I think, of this duality. When heroin in Black and Brown communities was deemed as the primary social problem, we witnessed an overwhelmingly punitive response, the militarization of local law enforcement, the expansion of stop and frisk policies, unprecedented levels of searches and arrests, all resulting in the world's highest rate of incarceration. And this was designed with almost laser precision to subjugate people of color, Black men in particular. In contrast, when prescription opioids became one of the dominant social problems, we see calls for treatment, compassion, and a public health approach. So this racialized duality pervades the entire drug policy ecosystem. It affects who accesses treatment and resources, and heavily influences our own understanding of drug use right down to specific substances. Fentanyl is a really good example. Last year, members of our team analyzed media and law enforcement narratives of fentanyl seizures and fentanyl overdose. And what we found is that when white people experience a fentanyl overdose, they are typically portrayed in the media as victims, essentially absent of agency. The blame rests with others, right? The dealers who sold them the substance, the traffickers who brought fentanyl into the United States, or the international Chinese factories that produced it. So put another way, fentanyl is depicted as a weapon inflicted on white society by others. And this has led to calls for drug-induced homicide laws, increased enforcement at the border, and other punitive measures. In contrast, what we see in the Derek Chauvin trial and many other cases of police brutality against people of color that involve drugs in some way is that fentanyl use is depicted as a choice, as a consequence of bad decision-making, or indicative of some kind of moral failing. And the racist stereotypes that we see in this case go even further. We heard narratives that fentanyl and other drugs lead to superhuman strength in these men. Not only are these narratives racist, but they in no way reflect the true effects of these substances in the body. Fentanyl is not some kind of super potent bioterrorism agent. It's used safely every day in hospitals across the country to treat severe pain and in anesthesia. Fentanyl powder can't be absorbed through the skin. It doesn't get into the air and is inhaled, and it doesn't cause superhuman strength. In fact, the primary effects of fentanyl, as in other opioids, are respiratory depression, shallow breathing, and loss of consciousness. We saw none of these symptoms during George Floyd's murder. And yet law enforcement agencies continue to trot out racialized myths, and they can be effective in influencing public opinion because of the very high degree of stigma that's associated with certain kinds of drug use and the extensive misinformation that's been perpetuated for decades. And so what can we do, I suppose? I invite members of the audience to think about drug policy reform as central in the goals of a broader movement for social and racial justice. And there are some important first steps that I wanted to highlight. We can support efforts to decriminalize simple possession of illegal substances. There's a bill right now in the Rhode Island House that seeks to do just that. We can work to greatly reduce or entirely eliminate pretext traffic stops, which are frequently used to search for drugs in vehicles. In Los Angeles, Black and Latino drivers are 4 times more likely to be stopped and have their vehicles searched for drugs, despite the fact that white drivers are actually more likely to be found with drugs in the vehicle. And we also need to expand laws that allow persons who have been previously convicted for misdemeanors or felonies related to cannabis possession to have their conviction records expunged so people are not saddled with those records for decades. And in the bigger picture, of course, we need to completely rethink the way that we address drugs and drug-related problems in this country with racial justice at the center of this discussion. So I think I'll leave it there, and I very much look forward to the conversation and discussion.
Thank you very much, Brandon. I really appreciated that. Now we'll hear from Donnell Williamson. Donnell?
Thank you so much. Thank you for the invitation, Professor Rose. Thank you, CSREA, for creating this space. I'm also grateful to serve on this panel with so many amazing professors and faculty members. So I've sketched a few notes and ideas that I'd like to turn to now. In 1776, when the framers penned the Declaration, they wrote that, and I quote, "It was self-evident that all persons are created equal," end quote. A few years later, they shifted their equality to classify my ancestors as 3/5 of a person. Nearly a century later, the author of The Souls of Black Folks surveyed the conditions of Black people and responded to America's long commitment to inequality with George Floyd in mind, saying that a system cannot fail those it was never built to protect. Chauvin's guilty verdict is a far, far distant place from receiving equal protection under the law granted to all persons by the Constitution. Let me explain why. Equal protection under the law would require police officers balancing empathetic concern for and fair treatment towards Black people, opposed to balancing a knee on a man's neck for nearly 9 minutes. Equal protection under the law entails equal access to the voting booth, water and snacks for those having to wait in long lines, plans for early voting, and extended hours to vote with the option to vote on Sunday. Equal protection under the law dispatches social workers and mental health professionals in lieu of armed police officers. It's educational, social, economic, civic, and political reparations. It's justice in place of a verdict. The moment Chauvin was found guilty on all 3 charges, Americans all around this country were simultaneously indicted and found guilty. Since protest, activism, civil disobedience, and social unrest lifted the veil of police immunity and dismantled the blue line of silence, states throughout the country have drafted, voted, and signed legislation to criminalize those who take to the streets, protest, and voice their discontent for the oppressive system. Let's be clear, the very activism that indicted Chauvin now indicts the Black community who have employed protests to mitigate and combat the many injustices literally choking the life out of them. These injustices aren't just police brutality. Wherever you turn, Black people somewhere in this country are being killed because they're overworked and unpaid, poisoned by unclean and unsafe drinking water, expected to endure pain and trauma in inhuman ways, and then labeled superhuman for having done so, imminent death from high rates of all types of medical diseases, ranging from high blood pressure and cholesterol and foods that were supposed to provide comfort, to doctors killing mothers on delivery tables, constant battle with all unapproved injections of hateful forms of white supremacy for their own mere survival, so they do to one another what white supremacy has done to them, forced to attend dilapidated schools with secondhand educational resources. Communities are destroyed with new highways and infrastructures, and then when it's all said and done, they're commended. They're commended the same way the Speaker of the House, Nancy Pelosi, commended Floyd a few days following the guilty verdict when she thanked George Floyd for sacrificing his life on the behalf of democracy. This is a verdict. This is not justice. And these are only a few of the injustices Black people endure. So when I think of justice, it's really hard to view it as a guilty verdict when the system recycles itself with the same microaggressions and anti-Black racism that killed George Floyd. While some feel relieved, my airwaves and lungs continue to hold the breath that I've been holding since the Zimmerman trial after the death of Trayvon Martin. There's a difference between a verdict and justice, and we must hold these two things in tension. I'm reminded by one of my favorite passages in Baldwin's No Name in the Street when he says, ask any Mexican, any Puerto Rican, any Black man, any poor person, ask the wretched how they fare in the halls of justice. And then you will know not whether or not the country is just, but whether or not it has any love for justice or any concept of it. What the Chauvin trial taught me was that it takes the courage and the bravery of a 17-year-old high school student to stand and record the death of a Black man to obtain a verdict. Because without Darnella Frazier's recording, Floyd's death, according to the Minneapolis police report, which you can look up, released the following day, would have been ruled an accidental killing. And despite the irrefutable mounds of evidence, the defense tried to prosecute Floyd's past decisions in carbon monoxide as the reason for his death, even while the video showed Floyd trapped under an unempathetic knee and an unyielding concrete. Justice, in this case, would require balancing the scales. What we need, in Baldwin's words, is a love for justice and equity that is applicable to all persons. And unfortunately, little Gianna, Floyd's daughter, would never be able to hug her father again. As a result, I personally feel numb. I'm numbed by the nonchalant and inconsiderate attitude that we have towards humanity. I am not, however, hopeless, because I believe that despite the hell America has thrown at Black folks, there's one thing white supremacy has failed to strip from us, and that is love. It's evident in the tears we shed in hopes for better days. It's here in the community that has gathered on this Zoom call. It's the smothering of Luther Vandross's Never Too Much, the joyous and melodic instrumentation in the introduction of Evelyn King's Love Come Down, or the honeydew aromatic flavor found in Anita Baker's Sweet Love. It's the sacred and savory scent of a home-cooked meal or a warm embrace. Though we have a verdict, I'm hopeful that with love, this country will one day eradicate white supremacy and begin to embody what John Coltrane called a love supreme. Thank you.
Thank you very much, Donnell. Really appreciate that. And we will now hear finally from Professor Emily Owens. Emily?
Hi, good evening, everybody, and thank you, Tricia and the CSREA for hosting this event and for inviting me. I am really moved by all the comments that I've just listened to, and will speak for a few minutes here, I hope not too long. So among the many effects of trauma on the brain is the inability to live in this moment. And I'm a historian, so that's already kind of hard. So my comments are sort of shaped by dwelling a little bit in the past. So among the many effects of trauma on the brain is the inability to live in this moment, because one finds themselves psychically stuck in the moment of pain, of heartbreak, and of dislocation. Awaiting this particular verdict, I felt myself stuck in the very long tradition of referenda on Black life and Black citizenship, brought forth by Black litigants like Dred Scott, brought forth by the resistant corpses and defiant mothers of the Black dead, Emmett Till, Trayvon Martin. I followed as news coverage made connections to the 1991 spectacle beating of Rodney King, and thought of Elizabeth Alexander's then prescient suggestion that it was these incidents, she wrote, of, quote, Black bodies in pain for public consumption, that we come to understand ourselves as, quote, a people. I found myself dragged back into the immediate past of not only non-convictions, Martin, King, Brown, Bland, but also of non-indictment, as in the cases of Breonna Taylor and Eric Garner, wherein the state decided there is not even a question of a crime here, let alone a crime itself. I wish I could say that the guilty verdict was really satisfying, but it's difficult to celebrate knowing how very likely it was that this obviously depraved act looked so much like the actions of so-called reasonable officers, those who keep holding on when a man says, I can't breathe, those who tell jokes while a man aspirates in his own sick under a hood. Why was that hood there? I don't enumerate those other cases to say that Chauvin's conviction doesn't make up for all the others, or to open up an otherwise worthy conversation about reparations. I think in this case, the question of repair is in so many ways too far gone. But I bring them up to highlight the cultural structures that make the certainty of a guilty verdict in this case feeble, more like a game of chance than like a legal science. My colleagues in the hard sciences judge an experiment as credible if it is possible to replicate the results. And I think there's little about this case that suggests that the result could be reproduced. But if there is a victory here, I think one of the central victories in this case is in the type of charge or charges that were filed and eventually won, that this was not a civil case, but a criminal one. I'm interested in that because the history of African-American success in the courts is marked primarily in civil courts. Think of Brown v. Board of Education, for example, or much more recently, the settlements that cities paid to the families of Philando Castile and Breonna Taylor. Black people have used the civil court to great effect, and so doing have created a tradition that says we will confront the state because the state does not typically stand up for us. In a criminal case, it's the state's job to say, we care about this problem. That's what a criminal case says. Regardless of whether any individual person or family cares, the state cares. In historian Laura Edwards' framing, the US criminal legal system is set up to protect the peace, what she calls the peace. And so when the state of Minnesota brought suit against Derek Chauvin, the state made a claim about citizenship and about peaceable existence within that jurisdiction. The state said, it is not okay to murder someone, even this kind of someone, in broad daylight. That constitutes, they seem to argue, a disruption of the peace, and the state has an interest in redressing that behavior. To the extent that Black people have yet to experience preemptive protection under the law, the civil law has traditionally been a space in which we have found some forms of validation. In civil court, though, winning typically means collecting a settlement, money, for, quote, damages. Here, harm and life are pushed to the side, prevention of harm becomes basically irrelevant, and restitution or justice is formulated in cash. Black life is more often recognized as worth something when that something is cash, reifying the fundamental property relation that constantly haunts us. Imagine for a moment what it would have meant for the Dred Scott decision to be called Missouri versus Sanford instead of Scott versus Sanford, wherein the slaveholding itself was configured by the state as a crime. Here, in the reality of the situation, Dred Scott had the audacity to challenge his former owner in court. It should be noted also, as an aside, that a very similar pattern of near impossibility for conviction, but some frequency of cash settlement exists in sexual violence prosecutions across racial lines, haunted as women are by our historic position as property-like. So the appeal of a criminal conviction is that redress takes the form of a statement by the state, a willingness of the state to sort of stand up for a Black life. But of course, the name of this case defines its most prominent omission. The proper name of what we've called the Chauvin trial is the State of Minnesota v. Derek Chauvin. In this title, the absence of the institution of the Minneapolis Police Department as a defendant flags that Derek Chauvin was prosecuted as an individual, an aberrant individual, they argued, erasing the institutional jurisdiction and uniform in which he killed George Floyd, focusing our attention on said individual and allowing the institution that trained him, gave him a gun, and sent him to that street corner on May 25th, 2020 to evade culpability. So if the state is, in this anomalous case, willing to hold Derek Chauvin accountable for the murder of George Floyd, thereby bestowing the protections of citizenship and inclusion onto Floyd in retrospect and in retrospect only, then it is also simultaneously saying that the police force itself is not the problem. If Derek Chauvin's actions constitute a disruption of the peace, then the Minneapolis Police Department does not disrupt the peace. Thus, the cops as an entity remain intact, as a singular cop is cast off. We do well then to worry, as Tricia Rose reminded us in yesterday's Race and Anti-Racism in America series, about the small victory among the ocean of non-convictions and non-indictments, in that such a victory is a potent, comforting, irresistible distraction from the baked-in violence of our police state and our social world generally. We should read this guilty verdict then as a clue about our cultural common sense. If we, as surrogated by this particular jury, can agree that this violence is unacceptable, what does that tell us about what we will imagine as acceptable? We've had video evidence before. We've had abundant evidence of cruelty, of excess, of miscalculations, of mistakes. I think about the cases I read for my research. There are very few cases in which antebellum courts prosecuted white people for violence done to enslaved people, but they do exist. And in those exceptions, the violence was usually called cruel. And in a way, that particular violence, that which was worthy of prosecution, mapped better the contours of acceptable violence, mapped the edge of acceptable violence than of what the extreme might be. So it is this case then that asks us, what force of will, what force of intellectual and emotional determination must it take to pinpoint someone's windpipe with the blunt instrument of a knee? If this is beyond the pale, then this trial has shown us how very much remains within the purview of so-called reasonable officers. And by the way, this verdict reaffirms what we know, which is that for violence to be recognized, the victim mustn't be armed, he mustn't be running, she mustn't be trans, he mustn't be too tall of a child, she mustn't be dating someone with ties to the drug trade, he mustn't reach for his phone. I have to say I'm also beleaguered by the nonsensical and abundant ideology about the already dead and dying nature of Black people's bodies, ridden with heart disease or drugs or both, that was entered into the record as evidence in this case. Should we be glad that it was possible to prove that crushing someone's windpipe was the cause of his death, even if he had underlying conditions? In what world is that logic possible? In what world could a person die of heart disease in isolation of a person pressing on his neck? In what world could a drug overdose have predominated, preempted, and also exempted the pressure of the full body weight of a person on your neck? I don't get that. I honestly don't get that. As the historian Walter Johnson has written, court records and testimony are full of lies. We think about that as historians looking at past archives, but I think it's really important here too. What matters about the lies that people tell in court is that when people tell lies, they have to be worth believing. You only tell a lie in court if it might be worth believing. And so I find myself here more distracted and aggrieved by this existence of this particular set of defense tactics than I am that they didn't work this time. I want to end briefly on a personal note, having nothing to do with comparison, but just as a reflection on the breadth of modes of living within racism, from the acutely fatal to the utterly mundane. After I'd been asked to provide comments in the event of a verdict, but before the verdict itself came down, I was stopped in my car by a cop. I was driving on the highway with my family, and I got stopped for the first time since I was a teenager. The encounter was by all accounts routine. The encounter was by all accounts terrifying. These two things are compatible in a world in which fear of the police is entirely reality-based. I could have said to the cop, I didn't do anything wrong. Or I could have said to him, I presume you're a racist pig and this traffic stop is a sham. I could have continued driving when he turned his lights on. I could have continued adhering to the speed limit as I had been doing when he flashed his lights to have me pull over. But I had my kid in the car. And I actually like myself pretty well too. I didn't want to ruin my life or even my afternoon, and I certainly didn't want to sacrifice them. So I stayed very still. I used my most calm, clear Ivy League English. I moved very slowly, and I kept my hands visible when he asked for my license. I told him when I was reaching for my wallet, and I scolded my partner when she opened the glove box without announcement. Historian Rebecca Scott describes the flight of Haitian refugees during the Revolution thus. These Black folks had been legally freed by Toussaint Louverture's declaration of a free anti-slavery society in 1793 and the subsequent ratification of abolition by the French Convention in 1794. But when they fled the war-torn island on boats that carried their legally free bodies into port cities, Santiago de Cuba, Baracoa, and New Orleans, they arrived in places where slavery was not only alive and well, but expanding rapidly. And so when they disembarked, they had no reason to believe that colonial officials would take seriously their assertion of freedom. Indeed, Rebecca Scott explains, for a disembarked person to, quote, to try to face down a port official and assert firmly that one was free because of the achievements of Toussaint Louverture and the Haitian Revolution would have been reckless beyond words. I found myself in trans-historical community with these emigres from the first Black Republic, the only logically coherent liberal revolution of its age. I thought to myself, as I politely thanked the cop and drove away, that it would have been reckless beyond words to have done otherwise. I want to close with the words of the great radical Black genius, Nina Simone, who in 1963 wrote a song for her daughter. It begins, I wish I knew how it would feel to be free. Thank you.
Thank you so much, Emily. Wow, this was an amazing, amazing group of comments and reflections by all of you. We are going to start discussing these, presentations and questions with the audience. So I think everyone will be coming to the Zoom screen shortly, and we should be in visual community. I wanted to sort of, that was just really amazing. So first of all, I don't even know what to do with all of that. There's so much in this. And before I ask a question and then turn to some of the questions in the chat, I really want to thank you all for agreeing at a moment's notice. And I want to tell the audience that CSREA decided that no matter the verdict, we really felt that there should be a conversation about this, which is a theme that I thought was very important in a number of the comments here, which is, what is the value of this verdict? Is it justice, as Donnell was saying? How do we position this so-called victory if we think about Nicole's comments regarding the fact that it was never supposed to go to trial, right? And that in fact, had it not been bumped up to and taken out of the hands of the local DA, we wouldn't be even having this conversation. The context of the notion of a perfect case that Bonnie mentioned, and how important that is for thinking about what's going on here. And I'm just wondering if all of these themes can be sort of just quickly attended to, maybe just by the people I mentioned, because there's so many of us. I'll sort of, I don't know if everyone responds to every question, we'll be here much longer than anyone will allow. So, if maybe those individuals could just sort of think about what, how we should understand this question of the legal context. Can the rule of law, can democracy, can we expect the court system to function in a way that, or be forced in a legitimately significant way to do the work that needs to be done for racial justice? Or is it just the only tool we fundamentally have and we must work with it? Or does it possess this possibility? I'm going to start with Bonnie, then Nicole, then Donnell, and then Emily. And then Brandon and Jonathan will come to you the next question.
Okay, I'll go first. I want to thank everyone for everything that's been said today. It's been very good to listen to all of you. I think what I was trying to think about today was the Attorney General of Minnesota's effort to both have an impossibly narrow case that would generate a verdict that would maybe be an event, that could maybe create some momentum or add to the existing momentum of a social movement. And at the same time, what I was interested to see, because I was feeling quite critical of that, as many of you seemed like you were as well. But at the same time, as soon as he had a verdict, he was trying to show how broad the ambition was alongside the narrowing. And I was interested in that complementarity, partly because what it invites us to think about. I'm sorry. Not only is that loud, I apologize, but it's the offspring, so there will be many more that come next. I'm sorry. So, I think he was inviting us to think about how to be very strategic in the use of law in some of the ways analogously to the things that the decisions and the tactics that Emily was pointing to in her talk. So if you make it narrow and you let the standard be as high as it is, and the case has to be perfect, and you just try this one cop and you don't implicate the police at all, you might get the verdict. Now that's a terrible betrayal, right? It's a terrible betrayal. It doesn't address the wrong at all. But what if, and I don't think it's right, but I want to, what if you can then leash that to the broader social movement? What if you can leash that one win to all the other non-wins? What if in that win, Gwen Carr can find some peace and representation, just like people have to find, Black people have to find representation in civil suits rather than in criminal, because the state will never, or has not yet, and will likely never embrace them. So those are questions. I don't really have the answers, but I think that what Ellison did was he put those questions up for us to think about, and to take as the challenge in the next steps, because this is clearly a step in something, and what it's a step in is partly going to depend on how we receive it, criticize it, and lift it up or down. So,
right. Yeah, no, that's very helpful, Bonnie. Thank you. Nicole?
Well, at the core of the research that I do, I go back to Du Bois. He called the criminal justice system a double system of justice. And so I would say the courts are for white people, largely, and that the court system that Black and brown people are accountable to work in a totally different way. I would call it a shadow legal system. I brought up the case of Cook County, Chicago, and Minnesota, because I'm saying you're seeing the same cases. Stage 1, someone's dead. Stage 2, we lie about it. Stage 3, we create a narrative. Everybody gets in line with the narrative. We pass it to the prosecutors. Prosecutors go along with the narrative. Why? They need us. They need us to win cases. Institution upon institution, covering and covering and covering. I was at a critical race conference at Boston University, and a critical race scholar challenged me and said that my research in Chicago was not generalizable. Said what's happening in Chicago is just the worst jurisdiction. And I said, so you're saying racism is not generalizable? It's just a problem of Chicago. That's what you're saying. And I said, show me the magical jurisdiction where there's officers that are charged with murder, because I know people are dying every day. I know it. Where are they held accountable? Where are these court systems? So I partnered with an ACLU attorney, and we created an article called To Serve and Protect Each Other, help prosecutors help police get away with murder. That article came out 3 days before George Floyd's death, 3 days. And I felt a sense of rage because the researchers in my field have failed to critique the court system as the central location where police officers are protected.
Right.
They basically are executing people on the streets. So the death penalty is not under the court's provision. They get to decide who gets to die and live, judge, juror, and executioner. And then when something quote unquote goes wrong and they come under public scrutiny, they own the courts as well. And so to me, I continue to push that, because if you're a legal scholar, people still think that criminal procedure is going to protect you, and it won't.
Right. Oh, okay. Yeah, I'll come back to that. I have a question, but let me keep going. Donnell, and then Emily, and then I'll bring in Jonathan and Brandon with the new question.
Yeah, I just want to say that's powerful. I just kind of want to add on to what Professor Van Cleve said and say something along the lines of, there's a cultural and political disconnect that I don't think people take into consideration. So as much, as I want to kind of give in to the court system being fair and equitable and equal and just, it's really hard to bring that about very well because of what Professor Van Cleve said. There's two systems that exist, as Du Bois pointed out to us. And so until there's some type of, reconsideration, rethinking, very much a revolution of how we govern and how we do the judicial branch, right? How do we not just, when it comes to like penalizing someone, but how do we neighbor, right? On a very, very core piece, right? Like, how do we relate to one another? How do we interact with one another? What does that mean, right? I think those things are very well standing as obstacles in place of us trying to get, more verdicts. And so, I think that the verdict is good. I think that the court system can do better. I think more than anything, though, we should try to figure out how to relate better to one another. Thank you.
Yeah. Emily?
Yeah, thanks. I think that I'm really struck, Bonnie, by what you're saying about the kind of narrowness of the legal strategy here, both as a flag for, I think, the history of Black people in the legal system. I mean, I think the history of the history of Black legal history, I guess, is one in which I think people have been extremely strategic at an individual and collective level to kind of build precedent. And that often takes place in the civil law. And whether or not cases are civil or criminal, I think that we see again and again at the level of small cases and at the level of landmark cases, the real narrowness of legal arguments that can win. And I think that good, bad, or ugly, that's just kind of the way that's not just the way like racist law in the United States works, although that's true. It's also the way that the law works in sort of the common law system, right? Like we need precedent, and lawyers make arguments in these really specific and strategic ways. I think the thing that strikes me as really important here is not just the kind of betrayal of the specificity in this case, but of the power of the people to put pressure on the state to bring the case. Because I think that there's such a robust tradition of non-indictment, of, as you're saying, Nicole, of covering up, of creating narrative, of narratives that work, of police, banding together, et cetera, to cover up murder. I think what's interesting here is that we've reached potentially a moment in which there's such an intense social pitch around this that I think prosecutors are asking the question that they don't have to ask in all contexts. I don't think that they are asking it consistently or across the board. And I don't think that by any stretch we have won or this is a win, really. But I do think it's an interesting moment in which we can validate the power of protest as shaping the social conversation in such a way that there is a little bit of like public shame that adheres to the legal system in broad company, not just in company of Black folks, not just in company of progressive folks, but that there is some political momentum around this. I think that's interesting. And I think that's a site that I think hope is too strong, but it does make me feel like all power to the people. That's the story of this case.
Yeah. And including, the fact that Ellison's election and his participation was also about placing people in political positions to be able to do this, not just the protest component. But Jonathan and Brandon, I wanted to bring you in on this other angle that I think both of your presentations shares, which is the ways in which Black failure, right? That somehow this notion that Black people are responsible for their own failures, and the idea that failure is attached to the Black subject, to the mind, to the body, seem to really fuel the broader context of the thing that happens to George Floyd and to so many others. And I'm wondering if you can respectively talk about education and drugs and the understanding of Black drug use in particular, and the ways those things sort of intersect. You talked a bit about it in each of your presentations, but I want to invite you to say more because, you know, one of the things that I think is such a big mistake is we think that it's the moment of the contact with the police when this story starts. But as you point out, Jonathan, you know, there's a whole superiority of whiteness and a whole educational process that we're asked to send Black children into, right? To give them good schools, right? And then, of course, every failure, every moment of failure is a stigma in both cases, whether it's drug-based or educational-based. So, Jonathan, why don't you go first and talk a bit about how those things might be, you know, playing a significant role here?
Yeah, thank you for that question, Tricia. I just think you really hit it, you know, on the nose in terms of what I was trying to get across, which is just that, you know, personally, it's difficult for me to really even follow the cases with much depth, just because it's, you know, it's just traumatizing. You know, like the first time I got pulled over by a cop, I was like 13 and I was walking, you know, like, it's, you know, like, I've gotten pulled over on my bike. Like, you know, like my first year at Brown, I got stopped going into my building, into my office. You know, like, you know, seeing how these trials sort of like unfold, I can't really do it. Like, I don't have the sort of mental, like, you know, I don't really have the bandwidth for it. And so, and what I think gets lost in the cases and in the details of the cases is all the episodes that lead up, you know, to these events, and the way in which, you know, we position Black people to sort of understand ourselves, and the way in which, you know, we don't talk more explicitly about how institutions, whether they're integrated or segregated or something in between, they aren't really talking about the kind of the kind of like shared love that I think Donnell was getting at. And so, you know, for me, it's like, well, what must institutions look like to begin to do these kinds of things? Because I think we think that success, we rest success on the laurels of optics, that we think about success in sort of racial progress as this, we are the world, there are so many different hues inside of a room. And we don't think about racial justice, I think, as something much more substantive than that. And I think the schools, the great thing about education is, you know, the schools could be sites for something transformative. They could be sites for, you know, discourse, and they could be sites where we learn about different cultures with richness and without the kind of like hierarchical imbalance that feeds into white supremacy and feeds into sort of racial divisions. But we don't do that. We use schools as sites where we tell kids kind of who they are. We tell Black kids that they ain't shit. And then we tell white kids that they're great even when they screw up. And then the system continues to sort of like do its due. And so I'm kind of going on a tangent here, and I'll throw it to you, Brandon. But I think, you know, what I really sort of sat with in the aftermath of the case was, I don't feel anything. I don't feel vindicated. I don't feel great. I don't feel terrible either. But then I look and I ask myself, well, where's the work to be done from here? And I think about the institutions that we have contact with every single day. And if we're not looking at those institutions and challenging them to create different episodes that lead up to the moments in which we have these interactions with the police, well, then we failed, and we're going to continue to see the same outcomes that we see over and over again, and we're going to continue to cry.
Right, yeah. Brandon.
Yeah, thanks, Tricia. So just to draw out my thought a little bit more, thank you for the opportunity to do that. You know, this duality that I talk about goes very deep, and it hits also on how we produce and reproduce reasons why people use different types of drugs. And what we do is we create narratives that assign sort of legitimate reasons for use of these drugs in predominantly white populations through a legitimized medical system, often, that people use these substances because of depression, isolation, you know, that is somehow legitimate, whereas we don't talk about, even in retrospect, really, that heroin and crack and many other substances are a function of oppression, racism, police violence, decades of violence in these communities. We still don't sort of even, I think, historically assign the motivations for drug use to some of those broader structures. Drug use is fundamentally response to someone's environment and someone's physical and social environment. And we still don't really see it that way, I think. I wanted to also comment on something that Professor Van Cleve mentioned, which I thought was very powerful, around how institutions intersect and interact and support each other in a white supremacist fashion. And another institution to add on to this is the medical examiner and death scene investigation system. In many states, coroners, medical examiners are within sheriff's offices, and there is evidence that coroners are put under pressure to assign causes of death in ways that downplay the involvement of police. One study even found that of the 1,100 police killings in this country, probably only 40–50% actually end up classified as a death involving legal intervention due to a police officer in federal statistics at the CDC level. So that also plays an important role in propping up this entire system, and epidemiologically just makes it very challenging to actually fully understand the magnitude of the problem when this kind of process plays out over and over again.
Yeah. Does anybody else want to jump in here before I move to something else? This is a rich line of, yeah, go ahead, Emily.
I just wanted to pick up on one thing you said, Brandon, which is that you were using a language of legitimate and illegitimate use of substances as a kind of like medical jargon, which strikes me as really, really parallel to the legal system's use of reasonable as a framework for like reasonable use of force, reasonable officer, appropriate use of force. And so I think that if there's an opportunity for perhaps minute intervention, I do think that the way that these discourses solidify white supremacist ideas and also obscure them through words like the reasonable officer, the reasonable use of force, the legitimate use of substances, that those are really dense phrases that contain within them just really dense histories of white supremacy. And so maybe there's an opportunity for pushing on more precise legal definitions and medical definitions that can lay bare the racial nature of those phrases and then potentially create space for changing them. But it just strikes me that that word legitimate just seems incredibly present in these cases, appropriate use of force, et cetera. Yeah. I think we do well to ask ourselves what it means that there's an appropriate use of force by the state on its citizens.
Yeah, that's really helpful. I guess, one of the things that all of your answers are really making me think about is, should our strategy be less about, when thinking about racial justice, Black Lives Matter, and social change, should our strategies be less about this focus on the prosecution, this moment of what we would like to call justice, but which Donnell reminds us might just be a verdict, but really back up to interrogate what Emily's pulling out of Brandon's point, right? Which is that the entire logic of the set of institutions that we've created are designed to produce these moments of contact with various points of the system. That is to say, you're not just in a dropout school, but you're in a dropout school because the other schools are white supremacy schools or superior schools, right? And then to train whiteness as superiority, and then your relationship to trauma is penalized and understood in a particular way, and so on and so forth. So if we think of this as a much bigger system, which is of course what I mostly do in my daytime, what do we do with that? Like, how would any of you, we'll take as many of you as we can, sort of recommend that we think about this? Because it's a pretty radical reformulation, right? We're not just going to go to the civil courts. We're not just going to try to prosecute a given policeman. because the arguments you're all making suggest that that's not going to make much of a difference anyway, although we'll take what we can get in this moment, right, as a footnote. What might be a more effective holistic strategy, and where might we think about, this is just speculative, but where might we think about locating it, right? Because we need to know what to do next, right? We need to know how to think about this next. Anyone, as a wide open floor, I mean, all of you. Yes, Donnell.
Yeah, thank you for that question, Professor Rhodes. And, I apologize earlier to your response that my response came, I'm sorry, earlier to your question that my response came out a bit fragmented, but I am a bit just shaken by everything. So it's really hard for me to put words together at moments such as these. I do kind of want to take into consideration what Professor Owens said, also Marshall, and thinking about this idea of policing and just the whole judicial branch, and saying I think there's one thing to kind of think about, how do we create precedents? How do we manage the legislative and judicial issues, whether it's political or judicial, right, moving forward, so on and so forth. But there's something to kind of take a step back and say, like, what do we do before we even get there, right? How do we stop an officer from arriving at a home, right, where there's two children interacting with one another in a very, brother and sisterly way, and possibly chasing their sibling around with a steak knife, and the police decide to pull out his officer and shoot a 16-year-old young girl? Like, how do we have this cultural divide in the country that is continuously forcing us, right, to comply with forms of white supremacy? And I really want to say that, we can give examples, right? We could talk about having more Black folks, policing Black folks, quote unquote, or having your own, being more visible within one's community. And I think that's, an option. But alternatively, I really do think there's a problem when it comes to any sense of knowing how the Black community as a culture, right, how they operate, how the Black community operates within itself, right? And I'm using this example of the 16-year-old in Columbus because I think it's evident of the very problem that we're facing, right? There's a pandemic, a global pandemic happening at this particular time. And it was very so happening on May 25th, 2020, when George Floyd goes into Cup Foods and gives them a counterfeit bill, right? We're talking about mass unemployment. We're talking about all of the things that are leading him to have to use this. But what we're not really concerned with is the circumstances that caused him to use that $20 counterfeit, and want to talk about a verdict, right? We want to talk about the aftermath of Chauvin placing his knee on his neck. Well, we don't talk about the circumstances that placed, that created that situation and created that circumstance. As far as it concerns me, I could care less about precedents, because even precedents doesn't always grant equality under the law. And we've seen that happen time and time again, right? We can very much say that this verdict is precedence for a similar verdict for Dante Wright, but that is yet to be determined. So I'm not sure if I'm hopeful as it concerns the judicial system. And so as far as giving an option, an alternative in that sense, I think we really need to talk about what happens beforehand. Thank you.
Yeah.
I wanted to respond. I mean, I agree with 100% with those comments. I think one of the issues that, is the city of Chicago, just as an example, every year they have a line item in their budget, their city budget. It's a police misconduct line item, and it's to the tune of $153 million per year, meaning the city anticipates violence from their own police force, knowing it will impact Black and Brown communities. But rather than choosing to revitalize those communities, they spend it on covering for the police. I mean, think of what you could do every year with $153 million. I'm thinking of Jonathan's work in education, right? Like, what would you do with that line item if you weren't paying for this type of negligence? I bring that up to say, we as voters, as Americans, are paying for this. We have prioritized this. The Department of Justice went into Chicago. They're doing the same thing that they're doing in Minnesota. They recommended 100 reforms to be enacted, right? And Rahm Emanuel, Lori Lightfoot, it wasn't just the Trump administration. These are Democrats saying that they support Black lives and they're concerned and all this other stuff, and they will not enforce those 100 reforms. They've only picked 25, which will do basically nothing. And so, I say that because, I'm really struggling because I have a lack of imagination for what the system could look like. I think we know the system doesn't have to have this level of violence because every day white people go to the suburbs and they actually are served and protected by their officers. So we know it's possible, but it's not built to do that for Black and brown people. And yet we continue to quote unquote invest in it. Even the new legislation coming forward by the Biden administration, they're now saying that we need better officers and they need to be trained in bias techniques. We've already done that. And guess what? That is code for let's put more money into policing rather than thinking about we used to call it net widening, which is criminalizing more aspects of social life, which include possession of drugs, which include traffic stops, which include all these other infractions, like selling loosies or using a counterfeit dollar. We've thought about that as mass incarceration scholars as putting more people into prison. That's one way of thinking about it. But I think we should start thinking about it as this: endangering more Black lives, because any interaction, as we can see, even if you're a child complying, is a possible deadly interaction. So I think we need those big global changes. Cities need to stop paying for this, and we need to start not just decarcerating. We need to say, stop criminalizing these aspects of life because they can result in death.
Right. I've unintentionally actually asked many of the questions that were in the Q&A and in my own words. So hopefully many of you heard your questions getting answered. I just want to end with one last question for a few of you, which is, what are your strategies? I'm really especially interested here in, I'm thinking of Jonathan and Emily who spoke about this, but Nicole, Donnell, Bonnie, Brandon, any of you can comment. You almost all of you described an emotion, a feeling as part of your presentation, right? Relief, we talked about trauma, rage. There's a lot of need for survival techniques, in managing this situation, even as far removed as we might individually be from this particular case. And in many cases, as Jonathan was saying, it's not removed at all because it's one big fat trauma memory of all kinds of instances that we face all the time. And I guess I'm wondering if any of you want to share how you process and manage this. And I think this is important because a lot of times we think about, communities that are intending to be progressive like Brown and, relatively diverse-ish, as different from the world. And yet here's all that's been happening, right? That got articulated here in real time. And I guess I want to encourage you in closing to let people know, what are your strategies for processing, managing, and surviving? In other words, what do you do in the face of this at your best? We know there are times we just crawl under the covers and grab a bottle of red wine or whatever your advice is. But I'm just saying, when you're at your best, what do you do? Jonathan, I want to start with you if that's okay.
Honestly, my job, and especially the aspects of it that I really love, are really, refuge. My students who are, curious and brilliant and bright and are, just as pissed off as I am. And opportunities like this to share spaces with colleagues who just make me feel like I'm not alone in the feelings and the sentiments, and can help sort of cope and process, I think. And then just knowing the fact that I ultimately have things to be grateful for. And I know that, it seems like with Black folk, we always have to kind of take refuge in that, but it is what it is. I love the fact that I can call my mom and talk to her about this, and I can call my dad and work through this. And, I have my friends, my family, and just knowing that the ancestors are with me too. It really comes down to some of the simple, the simple things that I enjoy.
Right. Bonnie? You're muted. It's okay. I know Zoom.
I apologize. I'm not sure that I have a lot to offer here. I in thinking about my various encounters with the police, which in no way rise to the level of trauma that my co-panelists describe, and yet at the same time left me shaky as well, and involved, fears of assault on a couple of occasions. I think that I'm not the first person to say this, is why I didn't say it today. I thought everyone knows about calls to limit the traffic stop, which is a scene of maximal discretion for police officers and minimal accountability. We didn't say it because I think everybody knows it, that qualified immunity and impunity are unacceptable features of policing these days, and that accountability needs to be rendered much more robust. And I think one example that we have from this case in particular, and also from Ellison's effort to mobilize this case on behalf of a public movement, is the work of a very small crowd in monitoring the police in real time and producing a record that outlasts the moment. And that's an important model. A lot of people have already been doing it, but one of the things that Ellison did after the verdict was to talk about those people and to talk about their profound acts of courage and the world that they've made possible. It's not going to happen without a lot more work, but without them, nothing would be possible right now. And those are the moments of collectivity and possible world making that, get me through the tougher days.
Right. We only have a couple minutes before people sign off. So I'm just going to go Nicole, Brandon, Donnell, and end on Emily. So just very quickly, your, things that you use for hope and how you survive it.
Well, I've been living these last 6 years, like I've had a pager that goes off and there's another case, and I talk on NPR and MSNBC. And so I'm literally processing it emotionally as I'm doing professional work and trying to help the public understand it. And I think for me, I have a medallion that was my aunt's, and I often just like say the name of the person and just breathe for a second, because I want to reinstate their dignity. And then I also want to be very mindful that I am saying the words that empower their story. And for me, I always put the lens on the people that create the conditions of marginality and violence. And I get hate mail. I was even told I shouldn't come back to the city of Chicago when this all began in the Laquan McDonald case. And that defiance gives me a sense of power.
Yeah.
And then I need to exit and protect my brain. And so I try to do it with gospel, because that gives me hope.
All right. Yeah, gospel will do that. That's a good one. That's a good strategy. Donnell, go ahead.
Yeah, therapy. Just throw that out there. Like-minded people, really surrounding myself with friends and family, because I can just leave this having to deal with the trauma. They know how to love me in the ways that I need to be loved without having to talk about these things. So being around those people really rehabilitates and heals me. Music, I love music, a good book, and then, ancestral power and strength, right, in God. And knowing that there's been people who experience worse, and that I can really get through this, and just really trying to hold on.
Yeah, all excellent. Thank you. Brandon?
I think for me, I've tried to and get a lot of solace, I guess, in learning out of reading and listening to Black scholars in this area, many of whom have been saying this for decades. So this is not necessarily new. Michelle Alexander, Carl Hart, Ayanna Jordan. There's lots of people in my field who have been saying these things. And I feel like myself have benefited so much from really engaging with their work and trying to sit with it on a deeper level. So I think that would be my advice for students in particular.
That's very helpful.
And other faculty.
Right, it's for everybody. That's good advice for all. Emily, the last word.
I write. I think that I just want to go back to what you said, Jonathan, about just doing this work. I think that it's like righteous, I guess, but it's mostly easier to think it than to feel it sometimes. And I find that thinking it is a useful process for working through the feelings of it all. And I work at the garden. I think that's really important for me. And I feel it in a way that feels like part of a long tradition of Black women in gardens. And yeah, I think about that Ross Gay poem about Eric Garner used to work in the Parks Department, and he planted trees, and those trees are still alive. And that's really powerful for me.
Well, I really appreciate that. Well, I can't thank you all enough for coming on, what we know is short notice and painful, difficult context where we're exhausted, frustrated, and just torn up about the feelings that even what was supposed to be success ultimately yields, right? Which is a recognition of the thing that is so much bigger than this one case that we're wrestling with, this huge, multi-headed monster. So having you all here has been incredibly informative and very nourishing for me. I hope everyone out there had the same experience I did. And, I couldn't be luckier to have all of you as colleagues. So thank you so much for being a part of this. And I'll see you all hopefully soon in person at some point. And to everyone who showed up, thank you very much for joining us. We'll see you again at another event at CSREA. Thank you so much, everybody.
Thank you. And thank you, Tricia.
No doubt, my pleasure. Good night, everyone.
Yeah.
Good night.